Good evening. Good evening and welcome to the American Enterprise Institute. For our latest installment of our Education Policy Debate Series, I'm Nat Malkus. I'm the Deputy Director of Education Policy Studies here at AEI. And so why are we here? Well, since the Supreme Court's 2021 decision in NCAA versus Alston, which paved the way for universities to pay student athletes, the college sports landscape has changed dramatically. And the NCAA is asking Congress for an antitrust exemption to navigate that inhospitable landscape. And that raises a raft of questions. Is an antitrust exemption a good idea? What does it mean for classifying student athletes as employees, for athletes' rights, for participating colleges and universities, for whether college athletics can survive as we know it? This is a debate worth having, and we're going to have it tonight on the motion, Congress should grant the NCAA an antitrust exemption. Now, this is going to be fun, but it's a formal debate, and it has a format and a winner. In a bit, we're going to start the debate with a vote from you, the audience. Then we'll have 3-minute opening statements from all four of our debaters. Then I'll take about 45 minutes to do some moderated Q&A. Then we'll turn it over to you, the audience, to ask your own questions, so get them ready. We'll wrap with 2-minute closing statements and then a final vote. Whoever changes the most minds wins the debate. We'll follow the debate today with a wine and cheese reception where we can join together for food and drinks and some discussion. Please take a moment to silence your cell phones, but don't put them away. We're going to need them in a couple of minutes. Typically, we jump right into the debate with the debaters. This one has a lot of layers, so we're going to start with a little bit of a tutorial, and fortunately for you, it's not by me. I'm going to ask Ross Dellinger to come on up here. Ross has the expertise to help lay out the basics on this topic. He's a reporter covering college football for Yahoo Sports since 2023, and he was at Sports Illustrated for 5 years before that. And if you want to keep up with what's going on in the NCAA, he's a pretty good follow on X. So I'll add that in there.
I just spent water, just spilled it all over my pants.
Perfect timing. Perfect timing.
Great start.
Speaking of your cell phones, we do have a way to follow the debate on social media on X. We have a hashtag AEI, NCAA, just all one word. And when we get to the audience Q&A, I'll be taking questions if you use that hashtag. You can also tweet them to me at @NatMalkus. But Ross, let's start with you. Or not with you, with the NCAA while we're here. The NCAA was founded in 1906. It's an organization committed to amateur college sports. Amateurs doing a lot of work in that sentence. What is amateurism?
Yeah, I think it probably depends who you ask. And I don't know how much amateurism is really left right now in college sports. You mentioned 1906. You know, the NCAA was created by Teddy Roosevelt, the president then, to put in safeguards because so many injuries were happening and deaths even with college football. So they created the NCAA, and I think for a long, long time you could call it an amateurism organization, right? And to me, amateur means you're not directly getting paid, and that obviously has changed, right? Starting 3 years ago, obviously with NIL, athletes started to get paid mostly by boosters and groups of boosters, and now we're moving on to rev share. So I'm not sure how much amateurism is still left. There are plenty of places in college athletics, though, outside of maybe D1 or outside of the top of D1, where you probably don't have much NIL and you probably won't have any or little rev share. So they could, in some way, I guess, preserve the amateurism nature. But at the top level of college sports, for the most part, it's pretty gone.
So let's pull that apart a little bit because it's not like students didn't get anything prior to this sort of withering of amateurism. What are just the basic education-related benefits that athletes would get?
Yeah, you know, it is a kind of a slow withering. Really, you could start in 1984 with the Supreme Court case, Oklahoma Board of Regents against the NCAA, where the conferences got the TV rights away from the NCAA. The NCAA had for so long controlled TV rights and controlled the TV money in the conferences, were able to get that from that Supreme Court ruling. And so slowly conferences in TV deals got bigger and bigger and bigger until you have the one struck just a couple years ago by the Big Ten, which is, I think it's 1.1 or 1.2 billion per year. And so because of all this money, right, coming into the system, you had courts and state lawmakers who began to say, well, wait a second, some of that money needs to go directly to the players outside of the tuition. And there is, as you mentioned, the plenty of educationally related benefits, right? Tuition, fees, books, lodging, meals. You pile it all on top of each other, and you do get somewhere between $125,000, $175,000 annually for an athlete. The value of all of that. That's what, at the power conference level at least. That's around the numbers that you get. But again, when you talk about coaches making $10+ million, football coaches making $10+ million, or basketball coaches making $5+ million these days, you have, again, lawmakers in court saying, this doesn't seem right. The athletes need more money than just the value of a scholarship and unlimited meals and medical. They need to get money in their hand. And so over the last few years, we've seen rulings from courts in state laws do that, right? We saw cost of attendance maybe a decade or so ago, which is about $2,000 to $4,000 per year for athletes in addition. And then years later, you saw the Alston ruling. That really was, in a way, cataclysmic event for the NCAA 4 years ago.
Well, let's talk about that, because
Yeah.
that's NIL, right? With name, image, likeness. Just briefly, what is NIL? Why is it so much money? And what's it doing?
The Alston piece is kind of NIL. It certainly paved the way for NIL. Right? You had Alston, which is about $16,000 in addition that athletes could get from their school. That ruling the Supreme Court made 9-0. A conservative-leaning Supreme Court, which never agrees, and they don't ever agree on anything, 9-0, but they agreed on this, that athletes should get the Alston money, the additional educational-related money. But with that, paved the way for NIL. And really, state laws really created NIL, right? California, Florida, state lawmakers got together and passed laws to open an avenue for athletes in their state to earn NIL, which is really just the buying of an athlete's name, image, and likeness for endorsement in commercial opportunities. And for years, the NCAA prohibited that. They prohibited athletes from selling a shirt and making money with their name on the shirt, right? Doing a camp, a football camp or something, and making money from that. For years, the NCAA prohibited that. And when the state laws were introduced, the NCAA had no choice. They had to get rid of their prohibition against NIL, and that opened the door for what we're seeing now, right, in the landscape we're seeing now, which is boosters and booster groups of boosters, right, distributing money, pooling their money and distributing it to athletes, and really salaries. They're really salaries, but they're disguised as NIL agreements, and we've seen that now for 3 years, and it's led us to the rev share era.
And that plays into recruiting. We have a slide right here that just shows, how many FBS players are entering the transfer portal in this post-NIL era. How does this relate?
Yeah, we had two big confluence of events here. We had NIL, again, the NCAA lifting its ban on NIL and allowing these commercial opportunities that have turned into salaries basically from boosters. So you had all this money coming into the system, and then you also at the same time, I think 4 years ago, the NCAA lifted its rule that allowing athletes to transfer at least once without sitting out a year. They used to have the rule where athletes had to sit out a season after they transferred, and that was obviously that was to prevent transfers. And so when you lift that rule, you had a lot of people flooding in. You get more transfers, but not only that, when you have offers being made of money, right, come play for my school, you just have this confluence of events that has created kind of administrators would call it an unregulated free agency, right? And that's kind of what we've had for 3 years or so, and you can see the numbers there. They skyrocketed for a reason, right? Athletes weren't punished for transferring, plus they got more money. They were able to get money now.
I got one more slide here to show you, and this is we're looking at the mean NIL earnings in orange for the entire roster of a football team, and the median on the right versus coaches' salaries for one coach on the left. I mean, we're talking about a lot of money here.
Yeah.
And the coaches have been receiving sort of a disproportionate share. This is part of the argument involved here, right?
It is. Part of the without getting too detailed on how an athletic department finances work, they are nonprofits. So I think there's always a goal every year to break even, right? There's not a whole lot of like money saving going on. So when all these football, and I go back to the Supreme Court case, allowing the conferences to control TV rights, which then flooded these many of the power conferences with money, and then they distributed that to schools that were flooded now with money. You have to do something with the money, right? And you can't, again, you're trying to break even, you're trying to pump up your athletic department, and so the money, mostly from football and men's basketball as well, was pumped back into the athletic departments to raise sort of all boats, all the other sports, right? Softball coaches saw their salaries skyrocket. Volleyball players began to take, charter jets, right? And all this was, and it wasn't only those things, right? There were some student athlete benefits added, medical expenses, extra meals, unlimited meals. In facilities, obviously gaudy facilities were kind of built all around the country as athletic directors were pumping the money back into the athletic department because they couldn't pay the football and men's basketball players that were making most of that money because of NCAA rules that they made, right? The NCAA is a membership organization, and the rules of the NCAA are made by college administrators, something that gets overshadowed quite a bit. And so because of these rules prohibiting direct pay to athletes, they have to pump the money into other places. And this is where we saw them pump it, right? Coaches' salaries, facilities, and other non-direct pay athlete benefits that we did see happen. The value of a scholarship I mentioned earlier at the power conference level, if it's $150,000 annually, that wasn't the case, 15 years ago, but maybe before all of the big time TV money came. But they did. They added mental health specialists. They added certainly meals and unlimited dining. I just visited the new facility at Texas Tech football facility. It's nicer than any NFL facility in America. And it's just about as nice as any facility I've ever seen in college, too. It's unbelievable. And that's where the money goes, right? It gets pumped back in. Instead of paying the athletes directly, it gets pumped to coaches and facilities.
So I think now we need to talk about the House settlement and revenue sharing. Give us a quick primer.
Yeah. So all of these lawsuits that have come about have been about athlete compensation. I see Val Ackerman's like shaking her head. Yes, we're all sighing. It's been about athletes' compensation. In the House case, without getting too nitty-gritty on it, it is about getting more money to athletes. Just right there, okay? It's about getting more money to athletes. And the NCAA, I think, had got to a point where it was tired of fighting these cases and losing. So it decided to settle the cases. And I like to break the House settlement into 3 parts. The first part is back damages that are owed to former athletes in NIL pay. And from 2016 to about 2014, if you played college athletics at the Division I level especially, you're going to get back pay. Now, it's not a lot. It's $2.8 billion over 10 years. It sounds like a lot. It's not, actually. A lot of major college football players are going to get $150,000 over 10 years, so $15,000 a year or so. A swimmer might get $5,000 over 10 years. So that's one piece of the House settlement, the back pay. The forward pay is probably the most interesting to people. And basically the NCAA, like it did with NIL, lifting its NIL rules, prohibiting NIL, it is lifting its direct pay rules to athletes, basically. So its last facade of amateurism, basically, is crumbling down. And so schools are going to be allowed to pay athletes directly in a system that is capped, like a salary capped in the NFL. And year one cap next year will be $20.5 million. So each school will have $20.5 million to distribute to their athletes every year. They're not supposed to go over the cap. There'll be a new enforcement entity that will police the cap, make sure all the schools stay under that cap. Now, they don't have to pay athletes at all. They're not required. It's just permitted to pay athletes. So that's the second part, and obviously a very big part. And the third part is the change to the roster and scholarship limits. And without getting in detail there, roster spots, roster limit, there doesn't exist roster limits right now under the NCAA in sports. And now there will be roster limits instead of scholarship limits. And because of that, there will be thousands of roster spots cut, because right now we don't have roster limits, and they're bringing them in, they're cutting the rosters down a little bit, invariably to probably save money, to avoid other litigation around scholarship limits that have come about. So that's kind of the three-part house case. And that, by the way, that cap figure of $20.5 million that each school can pay their athletes, they can pay their athletes however they want, right? It's up to each school's discretion to pay their athletes, and that $20.5 million cap will escalate because the cap is based on athletic department revenues, which continue to soar. And so that cap will get probably by 2028, 29, that cap will be 28, 30 million.
So I'm an ed policy guy, and I'm hearing they can do it however they want, but this next one, it brings up Title IX, which is gender equity, and we're just looking at male athletes' NIL earnings versus female athletes, and there's some big differences here. There's certainly big differences. I mean, football and men's basketball is the big revenue generator. I don't want to go down the rabbit hole, but how does the sort of education regulation of the university side mesh with the business side of this?
Yeah, this is Title IX and the splitting of this revenue share, how schools will distribute this revenue is probably the biggest issue of all this. In most schools at the power conference level, and a lot of them have come out publicly with this, we'll divide their revenue about 90% to men and 10% to women. About 90% will be to football and men's basketball of the revenue, and about 10% be to women's basketball, and then all other sports kind of fall into that category as well. And so if you got 20 million, about 17 or 18 million are going to football and men's basketball, and about 3 to 5 million are going to all other sports. That's their plan. Many of them expect as soon as July 1 hits, when the settlement will be implemented and you can start paying athletes directly, they expect a Title IX lawsuit pretty much immediately about that distribution method. But as many of them have told me, you have two choices here. You can split your revenue up to align with that graphic that you're showing, because I think many of us know in here that football and men's basketball accounts for about 90 to 95% of the revenue of an athletic department at the power conference level. And so they say we're going to split it based on how much revenue that the sports produce. And so you risk having a Title IX lawsuit. So that's option one, split it how they plan to, 90-10, and risk a Title IX lawsuit. Or option two is split it 50-50 and risk a lawsuit from football and men's basketball players saying they are earning most of this revenue. Why aren't we getting it? So that's kind of the two options, and that is a huge issue right now.
It's tangled. So I don't want to go too into the debaters' territory, but let's talk about this antitrust exemption idea. Why? What does the NCAA get with an antitrust exemption that solves some of these problems?
Yeah, the settlement is far from perfect. The settlement in the NCAA has been very clear about this. In fact, as far back as May, in a memo to schools, the NCAA said one of the negatives of this settlement is it does not protect the organization from future lawsuits. It does not, and that's also a big issue. So there will almost certainly be future lawsuits. And a few of them will probably be over what you just saw, right? The Title IX. Also, one of them is the anti-competitive nature of the cap, just having a salary cap. And then the third is over the enforcement entity, the new enforcement entity that's coming open that will police booster deals. And so those are probably at least three of what could be several avenues for future lawsuits. And the way to avoid those lawsuits, well, there's two ways. One is to get congressional protection. So the NCAA and the power conferences can enforce their rules without getting sued, can enforce the settlement without getting sued. There is another way called collective bargaining, right? And so these are the two ways, and right now the NCAA and the power conferences are pursuing option A, to no one's surprise, of getting congressional support to enforce their rules and codify the settlement without legal challenges and have a more stable, regulated entity.
And am I right to ask that part of this is why Congress? It's part because state law is not lined up, so there is an interstate competition problem.
That's true, and there's like part of the ask of Congress is probably three things. It's what I just talked about, and we need Congress to protect us, to enforce our rules and protect us from other litigation. But number two is to preempt state laws that are very varying. We saw as NIL arrived in July 2021, we saw a lot of state laws start to change. All these lawmakers trying to give their state and their state school the advantage, so they were changing laws. Now we're seeing the same thing happen, but geared toward the revenue share, right? You see states exempting, potentially, having laws of drafting bills that exempt athletes from paying taxes on their revenue share. So we're seeing a lot of that start. And so the second thing that they're asking Congress is preempt all these state laws. And the third thing is anti-employment, having a clause in a congressional bill that would deem college athletes as athletes and not employees. So those are kind of the three asks that they're making.
I care about sports and am sort of a passing fan, but I care a lot about American universities and about sort of the educational main mission of them. What's there to fear there?
Well, a lot. I think the tether between higher education and major college football specifically, but also men's basketball, that binding tether that's binding these two things is slowly stretching, right? And it's like I feel like it's like a rubber band, a really big rubber band that's getting stretched thinner and thinner and thinner until we are on the cusp of it. And I think we will get there very soon, on the cusp of it breaking, where American universities are going to have to decide whether they want to support major college football and men's basketball to a degree that includes, tens or even hundreds of millions of dollars, as this becomes a professional type of entity. And there's some hard conversations going on right now at many universities where the athletic departments are encouraging their university presidents to support your front porch, so to speak. You hear presidents say an athletic department is the front porch of university. It's time, I think, for university presidents to decide, are we going to support our front porch? And at many places, the front porch is supported, right? The G5, the group of five in FCS, in the non-football playing schools of Division I, universities subsidize their athletic departments by 50% or more. That is not the case with the power conference schools. It's around like 10% is the average. And that's the question of how many universities are going to give and send millions of dollars to their major college athletic departments to support the paying of athletes.
All right, Ross, bottom line, would an antitrust exemption be a solution to these problems?
I am a reporter. I'm trying not to have an opinion, but you got plenty of people at this table in front of me that have opinions.
Let's thank Ross Dellinger for giving us this intro. I'm going to call my debaters up in just a minute, but now it is time for us to take the initial vote. Now listen, you can point at the QR code, you can go to the address there. There's also the QR codes at your table. Make sure you go to the pre-debate vote. The post-debate vote is oddly for post-debate. And we need you to vote for or against or undecided. You will only have your vote counted if you vote before and after. So Ross, I'm going to let you take a seat. We're going to do a quick change, and then I'm going to bring up my debaters. I'll do some introductions, and after that, we're going to close the voting. So we have a fabulous set of debaters today. Arguing for the motion, we have Val Ackerman and Matthew Mitten. Val Ackerman has been the commissioner of the Big East Conference since 2013, and before that, she was the founding president of a small, unknown organization called the WNBA and the president of USA Basketball, which oversees the U.S. Olympic basketball program. She played basketball at the University of Virginia, go Cavaliers, and was one of UVA's first female student-athlete scholarship recipients. She's an inductee into the Naismith Memorial Basketball Hall of Fame and the Women's Basketball Hall of Fame, and she holds a law degree from UCLA. Val, thanks for coming.
Thank you.
Matt Mitten is a professor of law and the executive director of National Sports Law Institute at Marquette University. He's on the Court of Arbitration for Sport in Lausanne, Switzerland, serving on the ad hoc division for the 2014 Winter Olympic Games in Russia and the anti-doping division for the last two Summer Olympics. Formerly, he chaired the American Association of Law Schools section on law and sports and the NCAA's Committee on Competitive Safeguards and medical aspects of sports. He's got a law degree from the University of Toledo. Matt, thanks for being here.
Pleasure.
We also have two great debaters arguing against the motion. We have Catherine Van Dyke and Jim Cavale. Katie Van Dyke is the founder of KVD Strategies, a consulting firm that assists nonprofits, trade associations, and advocacy groups with antitrust and consumer protection policy initiatives and amicus briefs. She's also a senior legal fellow at the American Economic Liberties Project, where she's researched antitrust law and corporate influence of courtroom procedures. Before this, she was an attorney advisor at the Federal Trade Commission and coordinated their amicus program. Katie holds a law degree from Texas Tech. And last but not least, Jim Cavale is the founder of athletes.org, a players association for college athletes. Before that, he was the CEO of the Influencer app, just take out the vowels and you can spell it right, which he founded to help college athletes build bigger brands on social media and manage their NIL business. Jim played basketball at the University of Montevallo, where he founded NextSpecs, which is a recruiting network that connects high school athletes and college coaches. He's been on ESPN's list of the 11 biggest power brokers and advocating the future for college football, and he was named to Sports Business Journal's 40 Under 40. Can I get a quick round of applause for our debaters? All right, I've told them we're going to hold them to 3 minutes each, and we're going to start with Val Ackerman arguing for the motion. Val.
Thanks very much, Nat. I'm here tonight with my colleague, Matt Mitten, as a former student athlete and now a practitioner endeavoring to operate a college sports conference during a period of uncertainty and tumult. Professor Mitten and I believe that the creation by Congress of a limited safe harbor for the NCAA and its member schools and conferences is necessary to bring order to our unique sector and to help protect basic rules that are needed to allow the association to manage the complexities of national competition in 24 different sports for 500,000 athletes across 3 divisions at 1,100 schools. If you accept, as I do, that an enterprise built around national sports competitions is entitled to oversight by a national governing body in order to organize those events, establish playing rules, determine roster and eligibility standards, and create protections to ensure athlete health and safety, if you accept all of that, then it follows that the governing body should have the authority to enact and enforce those and other reasonable parameters so that its competitions can be run predictably, safely, and fairly. Without protection for those reasonable parameters, which at this stage only a congressional safe harbor can efficiently provide, college sports will be left facing a nonstop threat of costly lawsuits whenever its governing body, the NCAA, attempts to enact a rule. The confusion in our operating environment has been exacerbated in recent years as states have begun to take matters into their own hands and are passing a patchwork of laws that further erode the consistency and uniformity needed to manage this far-flung national enterprise. As Ross noted, that's why the NCAA is separately seeking from Congress a preemption of state law, again in selected areas, so that order in our sector can be restored and the extraordinary benefits enjoyed by our athletes can be maintained. Our opponents in this debate will likely argue that the antitrust issue can be solved if student athletes were classified as employees under the federal labor laws, as that classification would entitle them to organize and bargain with their employers, i.e. their schools, which in turn would trigger the labor exemption to antitrust liability. We would tell you it's not that simple. We believe that employment classification across all college sports is overkill and would almost certainly lead to the downgrading of college programs at best, and at worst, program elimination, as schools would be unwilling and/or unable to fund the increased costs of operations that would accompany minimum wage, overtime, workers' compensation, and other federal labor requirements, particularly for non-revenue sports, which are most sports on college campuses. Antitrust, employment, Title IX, and tax law are all colliding in the college sports space. We believe Congress is most equipped to reconcile these federal laws and provide the clarity needed to bring order to activities that are near and dear to the hearts of athletes, coaches, campus communities, and legions of fans all across our country. The alternative is interpretation by a disparate array of judges through a prolonged, piecemeal, and expensive process, and unfairness to athletes most of all, who are entitled to the certainty of reasonable rules that have their best interests in mind. Thanks.
All right, thank you, Val. And arguing opening statement against the motion, Katie Van Dyke.
Thank you, and thank you for having me here. I'm really excited to share the stage with such esteemed speakers. So as we get into this debate today, I thought it would be helpful to take a step back and talk about the actual laws that are at issue here. First and foremost, we're talking about the Sherman Act. That is the foundational antitrust law in the United States. The Sherman Act has been called by courts and practitioners the Magna Carta of free enterprise, and it prohibits any contract or concerted action that deprives the marketplace of independent decision makers. The Sherman Act is the law that was at issue in the Alston case that was briefly discussed earlier. In that case, a unanimous Supreme Court said that NCAA rules limiting certain benefits violated the Sherman Act. And more importantly, the Supreme Court said that the NCAA's stated goal of preserving amateurism was not what we call a pro-competitive justification. That is, the NCAA couldn't lean on amateurism as a get-out-of-jail-free card. We're also talking about the Fair Labor Standards Act, which many of you are probably aware of. It governs minimum wages and maximum hours, among other things, for employees. That law also is concerned with unfair competition, and its rules are considered so critical to maintaining a fair marketplace for employees that employees are not allowed to voluntarily waive their rights under the FLSA, and unions cannot bargain them away. The Third Circuit Court of Appeals agreed with the Supreme Court in a lawsuit involving FLSA rights that's currently pending, that the NCAA can't lean on amateurism to get looser standards in terms of whether or not athletes are employees. Finally, we have the National Labor Relations Act and the Norris-LaGuardia Act. Those two laws are what allow employees to collectively bargain. It's concerned with creating and enhancing workplace democracy, so employees who traditionally have less bargaining power can effectively negotiate with their employees as a group without running afoul of antitrust laws. All of these laws today and all of these lawsuits against the NCAA and its members are working exactly as Congress intended. They all are designed to balance the scales in the face of unequal bargaining power. And they all acknowledge that competition is a cornerstone of the democracy in the United States. And they all acknowledge that monopolies are destructive. The NCAA does already have the non-statutory labor exemption available to it. That's a big phrase. All it means is that if the NCAA college athletes are allowed to unionize, the NCAA can bargain with them and resolve all of the issues that you just heard about. Giving the NCAA a wholesale antitrust exemption is totally unnecessary, and it would flip about 135 years of US competition and labor policy upside down.
All right, thank you, Katie. Hearing second from the supporters, Matt Minton.
Good evening, everyone. It's a pleasure to be here, and I'm delighted to join Commissioner Ackerman because we're so closely aligned on this issue of why Congress should grant the NCAA a limited antitrust safe harbor. What's happening is antitrust law is being used as a sledgehammer to crack the foundation of NCAA intercollegiate sports, which for more than 100 years has provided more than 5 million college student athletes with the opportunity to earn a college degree and to play their chosen sports. What's also happening is it's draining literally hundreds of millions of dollars in treble damages and attorney's fees from nonprofit educational institutions. Recent judicial invalidation of NIL transaction guidelines, as well as intercollegiate athlete transfer and eligibility rules, effectively precludes virtually any current and future national, divisional, or multi-conference internal governance of intercollegiate sports to achieve socially beneficial objectives. When applying antitrust law, courts do not consider important national public policy objectives, such as ensuring that intercollegiate sports participation opportunities continue to be available to the currently more than 500,000 men and women who participate in more than 20 sports, with higher graduation rates than their non-athletic peers at the NCAA's 1,100 member universities. Federal antitrust law protects NCAA member schools from adopting uniform national NIL and revenue sharing rules, which are necessary to promote competitive balance and fair play among NCAA universities at the same level of competition. As Ross said, currently there's a hodgepodge of conflicting and different laws that are out there. So what are we proposing? Certainly not a broad exemption like baseball has. We're suggesting only a limited safe harbor of antitrust immunity that, one, restores national, divisional, and multi-conference internal governance of intercollegiate sports consistent with parameters established by Congress, and two, protects at least student athlete recruiting, transfer, and eligibility rules from antitrust challenge. Three, which is part of federal legislation creating a mechanism for establishing a nationally uniform university revenue sharing and third-party NIL compensation rules that appropriately balance fair compensation for intercollegiate athletes playing services under Title IX and preservation of participation opportunities in a wide range of men's and women's intercollegiate sports, including Olympic sports. And it's certainly not necessary to professionalize college sports by characterizing intercollegiate athletes as employees.
All right, thank you, Matt. And last, certainly not least, Jim Cavalli.
Really appreciate everybody being here and appreciate being on this panel with so many really great leaders who are trying to figure this out. Ross talked about how complex it is. I'm going to try to sum it up and really relate it to the issue. So first of all, a serial antitrust violator is asking for an antitrust exemption, okay? The second point I'm going to unpack is this is a fully commercialized sports and entertainment business that is commercialized as revenues, but not its expenses. And then the third point I want to make is collective bargaining through employment doesn't have to be the solution, but it's definitely not an antitrust exemption. There's a middle ground that allows for collective negotiating between athletes and the schools. So first, the serial antitrust violator asking for an antitrust exemption. You go back to the Alston case that Ross talked about, and Justice Kavanaugh, I should say, ended that when he hit the gavel, he said the NCAA is not above the law, right? In America, when you commercialize revenues, you've got to share those revenues with the labor. And he unpacked that in his final quote. And a lot of people will say that after that case was decided, this became the wild, wild west. But actually, it became the real world, where you actually have to pay the labor that is helping produce all the revenue. So that's the first point. Second point, fully commercialized revenues, but not expenses. The NCAA and all the sports, when you add up all the media deals across all the conferences, when you add up the media deal for March Madness, you add up the media deal for the CFP, is more than $10 billion a year. Matter of fact, 2 years ago, it reported $17.5 billion across all of it. That's bigger than the NBA. That's bigger than Major League Baseball. They both do about $10 billion a year. The difference? 50% of the money in Major League Baseball and the NBA goes to the players because they collectively bargain everything, including compensation, with those leagues. In the NCAA and the college sports realm, they get to decide however they want to do what they're going to do with that money, and an antitrust exemption would allow them to continue to be able to decide how to do it the way they want to do it. And then that third point, Val said that we're going to argue for employment. That is not our argument today. Our argument is in the present. In the present, college athletes are contractors. Okay, basically, now that revenue sharing has happened, they're not employees. And what Congress needs to do is not give an antitrust exemption to the NCAA. Congress needs to simply extend a non-statutory labor exemption that allows organizations representing contractors to be able to negotiate all of the rules, transfer rules, compensation rules, health and safety rules. And a partnership can exist that will end all future lawsuits.
All right. Now we're going to enter into a little mediated or moderated Q&A, and I get to be the moderator. Remember, it's a debate where a motion's for, so the burden, I think, goes to those arguing in favor of the motion. So let me pick up with one of the most provocative things we just heard. I think Jim said that the NCAA is a serial antitrust violator. To the degree that the NCAA is interested in a safe harbor, how do you respond to that? Is that in some sense true?
Well, no, that certainly is not true. And I think we have to go. One thing to clarify here is the Supreme Court has not struck down the NCAA's historical amateur educational model. The Alston case had absolutely nothing to do with NIL or with amateurism rules. All it dealt with was the legality of nationally agreed rules. And again, all NCAA rules at the national level are the product of an agreement among its member schools. And there, the court said you can't have national limits on in-kind benefits, or, I think the cap was 6,000, not 16,000. Schools could offer that much if they wanted in educational bonuses. Justice Kavanaugh, in his one-judge concurrence, I think it's striking that none of the other 8 justices joined him. He suggested that intercollegiate sports look a lot like professional sports. And they really don't. I think there was an acknowledgement that, well, you don't want to unionize them, but the non-statutory labor exemption should come into play, which is really problematic. You can't have one foot in the pro sports area and one foot in the intercollegiate sports.
I have one.
Can I respond
Jump
to that?
in.
So we already do have one foot in the pro sports realm and another foot in the amateurism realm. And it's basically the foot that's in the pro sports realm is with these revenue producing sports fighting to produce more and more revenue the ways they are with these massive media deals. That's pro sports. It's comped. It's a very easy comp. The part that's still got the foot in amateurism is the part that's not allowing for collective bargaining to occur to come up with all the rules. Because in all these pro sports, this is the pro sports and entertainment business. No, it's the sports and entertainment business. College sports is a part of it, and it's not able to take advantage of what collective bargaining does for the NBA, NFL, MLB. So that's where I think they already have one foot in both sides.
I want to ask a particular question to the side arguing for the affirmative. Jim says that college sports are sort of a business enterprise. Is that acceptable? Do we accept that premise?
You know, let me jump in on that one, because most college sports are not that, to be honest. I mean, we are where we are today because two sports in particular, football at the FBS level, not low-level football, because remember, there's two levels within the NCAA. So-called FCS is football championship subdivision football, which is a money loser for the schools in which it's operating. And then you have FBS football, which is the higher level of football, which is money losing at some of those schools. So you've got those two, that sport, and then you've got high-level men's basketball, which are the sports that have enjoyed growing commercial success over the last, I don't know, decade plus. And that's, you know, their successes have really brought us to this point. The fact is most college sports are cost centers for their universities. They're co-curricular activities. The athletes who are lucky enough to get roster spots might even get luckier still if they have their education paid for. That was me, frankly, at the University of Virginia. I was a student athlete in the early years of Title IX in a sport that brought 20 people to a game. I got my education paid for. I got into a school I might not otherwise have gotten into. I had life experiences that could not be matched in the classroom. And I got that debt-free and tax-free. And so the quid pro quo for most college sports is a pretty good quid pro quo. I think, you know, where the space is wrestling now, again, is how to deal with that first category of sports that Jim has referred to, and what's the fairest way of managing this enterprise, which is national in nature, where most of the sports are their co-curricular activities, not generating revenues for their university, but a handful are, and what's the appropriate way to balance the considerations when the law right now doesn't allow for differentiation based on revenue. That's one of the problems in the law right now. So you know what I think, you know, we're arguing for on this side is there some limited, not broad, to Matt's point, limited protection that can be offered so that the NCAA can figure out reasonable rules around the core elements of conducting national competition across these sports. Students are involved to a degree. We don't have bargaining, you're right, and we don't have associations, but we do have mechanisms for student athlete input to be worked into the system. Could it be done better? No doubt about it. No doubt about that. But in the meantime, I don't see any way around the uncertainty and around the continuing litigation without federal intervention of some kind.
Katie, I want to ask you about that, but I also, you invoked the Sherman Act, the FLSA. Those are certainly for businesses, right? In a business context, is college sports a business?
Yes, I have a few thoughts on that. First of all, we don't define a business on whether or not they make money. Businesses lose money every day. The fact that some colleges are losing money on sports doesn't make that a business enterprise. They have revenue, they have expenses, they decide how to allocate it, and that's how free markets work. Nor does whether or not somebody is an employee be decided by whether or not you pay them. That's decided based on factors like how much control does the company have over the person. Here, the the schools exercise significant control over athletes down to the hour of every day of their existence with these coaches in terms of when they wake up, where do they go? They provide all the equipment. The athletes do work for them that brings in revenue. They go to the field. They go to events. They have training. They have practice, et cetera. So we don't decide whether something's a business or whether something's an employee based on how much money is coming and going. It's the fact that money is coming and going between these parties and between the schools and between the customers, and between the consumers and between the students. So yeah, it's a business.
Let me ask Jim on this question about whether it's a business. It seems like, well, some college sports teams are in the business and most college athletes aren't. So even if you had athletes sort of represented in a bargaining space, aren't the money-making athletes, the revenue-generating sports, vastly outnumbered by the Olympic sports and the soccer teams that aren't generating a lot of revenue, and the list goes on and on? I'm worried that the sort of representation of students primarily is being attributed to major revenue generators, but not the full scope. Am I off base there?
Yes and no. If you really look at it, if you built an executive council of player reps at a particular school, let's use Notre Dame since they're independent, and you said, hey, we're going to have at least one player rep from every sport, but we're going to have a weighted amount of player reps from the revenue producing sports based on how much revenue they produce, right? And so you'd have more football, men's basketball, women's basketball reps on that executive council of college athletes than you would the other sports. Together, they would look at athletic department-wide issues like what are the floor for scholarship and benefits and funding for sports? What does revenue sharing look like in a pro rata format where the football and men's basketball players might get more than the rest? And a lot of other things like that they care about. Transfer portal, conference realignment. Do we want to be in a conference where we're flying across the country all the time, but we're asked to take a final exam because we hear academics is first, but we really can't even get our test going because we've got to travel back on a commercial flight across the country? Like, they care about a lot of things. And so all of these things can be figured out between the school and the athletes on an athletic department-wide basis. And then when you get into the sport itself, like football, those football reps can help negotiate with the football program on the minimum salary, the maximum salary, veteran bonus for staying, all those things. And the thing that I've learned, we've got 4,000 athletes now at athletes.org, mainly power conference, men's and women's basketball and football, but we have athletes in all levels, all sports, is when we get them together like we did at the CFP, where we had 50 power conference football players in a room for 2 days, and they vote on compensation, health and safety, transfer portal. I talk to ADs all the time. They're not that far apart. They could come to an agreement easier than both sides even know. But to think that it's got to happen through employment and collective bargaining is not innovative. We need to innovate right now in college athletics, and there's a middle ground to get this done. They don't need an antitrust exemption. They need a road to do that the way these other commercialized leagues have done it.
Yeah, I'd like to add to that. What Jim just described is exactly what's done in the NBA and the NFL. And those are, in fact, national sports organizations with lots of teams and players at different levels and coaches and et cetera. And, the CBA that the NFL Players Union has with the NFL is hundreds of pages long. And they worked it out and they negotiated all of these issues. They also negotiated health and safety issues, practice safety issues that, frankly, the NCAA doesn't deal with despite being in charge of regulating athlete health and safety. They don't do it. So there is a path. It's used by most other sports organizations in the country, and it's unclear why the NCAA and its members can't do it here.
Go ahead, Matt.
Can I respond? It's very clear. The NCAA's 1,100 member schools are made up of both private and public schools. Even if you could arguably characterize intercollegiate athletes in any sports as employees, it would only be athletes at private schools who would be permitted to unionize under the National Labor Relations Act. Those at public universities cannot. So let's take the Big Ten, for example. 18 schools, 16 public, only 2 are private, Northwestern, USC. The last time there was it's basically going back to what they're arguing is this ought to be a de facto employment relationship, which is impossible under existing law. When there was an effort to unionize the Northwestern scholarship football players 10 years ago, the NLRB said, can't do it. We cannot assert jurisdiction over those who are public employees, essentially. It just does not work. And I think we would agree that there's a commercialized aspect of college sports, no doubt, but it's largely two sports that generate the revenues, men's basketball and football, and it's largely at the Division I FBS, just the autonomy schools. And I think the real difference here is, I think it looks like, and we wouldn't dispute, that athletes who generate revenues should get a slice of the pie. It's probably going to be a pretty big one, but you don't want to just make it all that money going to male athletes playing two sports, and then those playing the other 20-some sports, schools say, well, we can't afford it. We're just going to make you, these are going to be club sports now. So that's the concern, is recognition of a commercial educational model will achieve the objectives I outlined. There's absolutely no need to move to a professional commercial model, which Jim and Katie are describing.
Val, I want to ask you about how Title IX intersects here, because we could say, well, they are commercial enterprises, but they're not educational enterprises. These are Title IV institutions, the vast majority of them. They are subject to Title IX regulations and gender equity. And I know the Department of Education, and at some administration, sometime in the near future, they're not going to care about your arguments about they're going to be a business. They're going to bring Title I suits, and they're going to be very difficult to negotiate. How does that layer sort of dictate where this might need to go?
Well, I think Ross in his opening remarks really laid it out very well. This is, I would say, again, as a practitioner, this is one of the most difficult topics now that folks are wrestling with, how Title IX will be construed under the new revenue sharing model. As everybody knows, this is the landmark law that mandates equity in the operation of men's and women's programs at educational institutions that receive federal funds. There are important questions looming about whether Title IX will require that half of the money generated by football and men's basketball, most of all, and that's paid by the schools versus third-party payments that are made by the collectives or individual donors or the brands. Those are not Title IX protected payments. And that's an important distinction in terms of how NIL rolled out. Those were third-party payments. Title IX didn't come into play. Now that the schools will be in a position to make payments directly, these are going to be very important questions. Is that money to be shared with mostly non-revenue producing athletes, men and women alike? Or is it fairer to direct the lion's share of those dollars to the so-called earners? I think Ross said it well. There's arguments on both sides of that. As many of you may know, there was guidance that was issued by the Biden administration in its waning days that said the former, that those dollars should be equitably shared. That guidance didn't last very long. It has since been rescinded by the current administration. Will that new guidance hold? Or will the differing sides of this issue bring on yet another protracted round of legal skirmishing? I'm in the camp that says it will. I think Ross is right. I think this is a litigation waiting to happen on both sides. This is an area where I find myself wondering, could Congress step in here? It is a federal law. It's the OCR that's managing the regulations. Right now we don't have clarity on this, and I do anticipate disparate approaches to this that will probably have people on both sides of the issue howling. And if there was any way for Congress to intervene and come up with some clearer standard that would stave off the litigation, turn it more into a black-white than a very, very significant shade of gray, then I think that would benefit the space.
I want to ask the opponents about this. I mean, is this question related to the antitrust exemption question? Is it separate from it? How do you view the Title IX aspects?
First of all, I want to say I'm not a Title IX expert. I'm an antitrust lawyer. But what I'm hearing is that the schools want to give most of the revenue to the male football players. Title IX might say, no, you have to split it 50-50. And the NCAA and its schools are saying we're going to get sued again if we don't split it 50-50 like Title IX says we have to. So what I keep hearing, and it just astounds me, is the NCAA saying, but the law says they can sue us, so make it so they can't sue us anymore. And it's like, no, You're a business, you have to comply with laws, I'll just say entity to take out that apparently controversial word. You have to comply with the laws just like everybody else. And what you're asking for here is unprecedented. And now you're saying, but we can't comply with Title IX either. It's like, what laws are you able to follow? I also would like to correct a few things that I heard Matt say earlier, respond to them, I guess I should say. First of all, courts do consider national policies like whether or not collegiate sports are beneficial. The NCAA's rules under antitrust laws are subject to what's called the rule of reason. There are two ways to evaluate these kinds of coordinated things. There's the per se standard, that's like, it's illegal, there's no defense to this. What you did is unlawful. Usually wage fixing agreements are subject to that. But the NCAA gets the easier rule of reason. And I can tell you, as a former plaintiff's class action lawyer, that when the rule of reason is applied to your antitrust case, you lose 90% of the time. That is a stat that is correct, I promise you. So the NCAA, and when they look at that rule of reason, what they do is say, well, is there a pro-competitive justification for this rule or this wage fixing that you're doing? And the NCAA told the district court and the appellate court and the Supreme Court, oh, our pro-competitive justification is preserving amateurism. And the district court and the appellate court and the Supreme Court said, okay, what's amateurism? And the NCAA and the conferences and the schools, over years and years and years of litigation, were never able to answer that question beyond amateurism means we don't pay them. And so the court said, well, you're telling us that you don't pay the athletes because they're amateurs, and they're amateurs because they aren't paid. That is quite obviously circular logic that does not survive the rule of reason, and that is why this violates the law. So courts look at these type of things. They look at what's the justification. They look at, well, is our collegiate sports beneficial? How do we maintain them? The courts realize that sports need to be able to make rules and agree on, that sports leagues need to make rules and agree on them. And they subject those rules to a lower standard because of that, and the NCAA's rules can't even survive the lower standard.
Briefly.
Yeah, so, to make this simple, to go back to the original prompt, antitrust exemption allows the NCAA and the schools to keep setting the rules on their own. Collective bargaining or non-employee collective bargaining allows the schools and the athletes to come up with the rules together, and it stops litigation. And so when you think about that, go back to what Matthew said. First of all, you wouldn't have the athletes negotiating with each school. Private, public, state laws, all the stuff you brought up, I agree with. There's a private entity about to launch that's going to govern college sports. An entity like that or another entity would need to be created to bargain with the athletes. It's the first thing. Second thing, and then I'm going to hand it back to you, Nat, because I know you said quick. We hold meetings at schools a lot, and we held a meeting at Notre Dame, and we had that player rep system where all the sports were represented, and we had more football and basketball athletes than others, but we had the room representing all the sports. They all agreed football and men's basketball should get more revenue sharing. They just wanted to know their sport was still going to exist. They wanted to know they were still going to have scholarships and benefits, and they were going to be able to travel in a way where they could still do their schoolwork. I think that they'll agree on more of these things once they get in a room together than people are giving them credit for.
College sports have become more complicated, difficult to govern, increasingly shaped by the pressure of big dollar sports. Let's put the big question on the table. Why not break off the big dollar sports? Why not make them franchises? I mean, they could just become another entity. Is that not a way to solve this? And if it is, are you willing to go there?
Yeah, I mean, I'll start, but I would just say, when you keep hearing over and over the truth, which is 90+% of the schools and the sports don't produce this revenue, the smaller portion does, that would be logical to try to figure that out so that you can at least have a system for the others that maybe reflects amateurism, but it's really hard to do when they're all in one system. And so, to think that you can have them all in one system and use the fact that the majority don't produce the revenue and are happy to just get a scholarship, that doesn't make it okay to not share the revenue with those who are producing the revenue.
Those on the pro side?
Well, I think it's back to the point that, Val very eloquently made in her opening remarks, is that we have the conflict of 4 different federal laws here: antitrust law, Title IX, labor law, and even tax laws. One of the things to consider is the IRS for years has considered the substantial educational value of a scholarship not subject to federal tax. Now, if we're moving to a pay-for-play model for certain sports, I think there's a pretty strong argument that even the scholarships ought to be taxed there. So, if we look at this, it's the problem is there's got to be some certainty. Under current law, you can't just carve out football. That was rejected 50 years ago. That was the proposed Tower Amendment when Title IX was enacted. The proposal was, well, take out football, that's different, because that has many more athletes than any other sports, and it generates revenues. Congress said no. That has not changed. That is still the law today. The problem is, how does that get resolved? Let me clarify what I was saying, Katie. So at virtually all schools, it's surplus revenues generated by football and men's basketball that cross-subsidize all the other sports. You could look at that as, well, that sounds pro-competitive because there are more intercollegiate sports offered. That was raised by the NCAA's member schools in the O'Bannon case as a pro-competitive justification, which Judge Wilkin summarily rejected. An appellate court has never considered that, much less upheld it. And under what Jim is proposing, you could have this issue. Let's say you have someone who represents the women's basketball team at a school, someone who represents the men's basketball team, and they come up with different, quote, collectively bargained agreements. Then you have a situation which happened a few years ago when the U.S. women's soccer team brought a suit claiming that we're getting much less than the men. And by the way, we are a lot better than the men's players. Look at how they've performed, and they certainly have. And that led to litigation. So you go down the one path, you might try to solve one legal issue, but then there's another one. That's why Congress has to step in and resolve the conflict between these 4 federal laws.
Now, you're a commissioner. What about just breaking off the big dogs and leaving everybody else alone?
Well, there's parts of that appeal to us, the Big East, as a non-football playing conference, and I'll explain that. In the litigations that we've seen, while it's probably impossible to allocate a definitive portion of each litigation to a particular sport, it would be my sense that most of the interest by the plaintiffs is in accessing the money that's been generated by football. Why? Because that's most of the money that's been generated from football. And the problem is that when the NCAA is named as a defendant in these lawsuits, that means that the liability for the suit, if it's an adverse ruling, hits every conference, even those that don't sponsor the sport of football, if it's a football-related lawsuit. And so that, I'll just confess, led to a lot of tension in the House settlement because of the way that the damages portion of that settlement were allocated. As Ross noted, the settled amount was $2.8 billion, representing back pay for NIL. The NCAA agreed to take on a significant portion of the liability out of its budget, which is funded by the NCAA men's basketball tournament. The NCAA does not receive a nickel from the college football playoffs. All of that money that you read about from television agreements and ticket sales and the like, not a penny goes to the NCAA national office, even though the NCAA national office funds a number of expenses related to football. And the NCAA defends lawsuits that are brought because of football, okay? So that's been a big bone of contention among a number of the conferences is, how that could have happened, to be honest. And I'll add further point, the $2.8 billion that's being funded principally out of NCAA basketball money is going to pay football players. That's where those dollars are going to land. So it's a long way of saying that if the big dogs, as you called them, broke off and formed their own college football association, then it's likely that the NCAA would not be sued for litigations related to football at that level. And that would immunize many conferences that don't have, that aren't the reason for those litigations from the liability that we're all now shouldering in ways that are disadvantageous to our schools and to our athletes and are going to result in some negative ramifications. I just want to raise one thing because Katie mentioned something, because when she said the word compensation, my ears perked up on this. I just sort of, for the record, want to make sure that the narrative is clear here. Student athletes who go to universities and have full scholarships and have the benefit of free educations that are tax-free, the benefits coming to them are tax-free, they graduate debt-free. While they're there, they get a host of benefits that have been growing over the last 5 or 10 years, ranging from lodging to travel to medical care to academic advising, post-eligibility insurance. There's a whole host of benefits. There is a value to that, and my remorse is that in the public discourse about what athletes get and don't get, there isn't a value ascribed to those benefits. It's not that they're doing any of this for nothing. They're getting a free education out of this to play the sport that they love and to develop skills that they can use later on in their lives that have, it's like the MasterCard commercial. It's priceless. And so for many athletes, it's the deal of a lifetime. It's the deal of a lifetime. And so that's why, while you could make a case, and I'm in that camp, that athletes in certain sports can make an argument that, hey, for everything that we're doing for our university, the fans that we're attracting to our games, the dollar value of the media contracts that are on our backs, we deserve more than a scholarship and medical health care and academic advising. It's a fair argument. It's a fair argument, and the House revenue sharing model will begin to address that inequity. But for most other athletes, the deal that they're getting is it's the deal of a lifetime, and that's what I worry about. That the benefits to all of those athletes could go away because of some of the decisions that could be made because of football and high-level men's basketball.
Katie, I want to ask you again about the antitrust frame here. Isn't there something special? Isn't there something unique here? I mean, is it just like, nope, just let it ride? It's a normal entity. The NCAA is tangled. It's tangled with these education. What should we make of that?
First of all, I will set the record straight that I am a college sports fan. I grew up in Texas in the religion of college football, go Horned Frogs. So I'm not anti-college sports. I want to make that clear. In terms of what's unique, I think the thing that the NCAA is asking for is unique. Literally nobody else, no other industry in the country has an antitrust exemption that says that you can just unilaterally set the wages for every employee in your industry. There's not some sort of like national restaurant association that says the wages for waiters are X and the wages for cooks are Y. This does not exist anywhere else. And what I would say is that if we are going to talk about changing the law, why are we talking about excusing the NCAA from complying with what are like really foundational laws in our country? Why aren't we talking about a law that does solve the tax problem? Why aren't we talking about a law that says, you know what, college athletes, whether they're at a state school or a private school, can unionize? Or why aren't we talking about a law that gives them employment status and that protects international students so that they can keep their visa and also get an NIL deal, or that says that college athletes, even if they aren't employees, can collectively bargain? There are a lot of other ways to handle this than just making the NCAA the sole entity in the United States that is excused from our antitrust laws in this way.
I have a quick, yeah.
Because I think what I would want to clarify here is what's being sought here is not wage regulation here. That's been handled by, in a manner of speaking, by the House settlement. Just, let's be clear here. Student athletes can make deals where they would be, for their use of their name, images, and likenesses, where the payments are made by third parties without regulation, or without a cap. The House settlement will provide for some management to make sure that there is a valid business purpose for the payment. and that there is a range, but there's no cap. There's no cap here. And then the revenue sharing arrangement that Ross has detailed and that we've also discussed here is being managed by a settlement. It's judicial approval of the mechanism for athletes to receive payments directly by their schools. What I think Matt and I are speaking about is some way to give the NCAA clear rulemaking authority about areas that are necessary to conduct national competitions. Think and to protect student athletes. So think rules around eligibility. Think rules around academic standards. We want to make sure that these are full-time students in pursuit of degrees and good academic standing at their schools. If it's not that, if they're hired guns wearing, the name of their university on the chest, and they don't have any connection to life as a student, then that's not what college sports is all about. And I think the NCAA has an entitlement to be able to manage eligibility in that manner. How we handle recruiting, how we handle player and athlete movement, all those things are the kinds of things that are being sought for this limited safe harbor. And I don't disagree that there should be a better mechanism for athletes to have a seat at the table and to be part of the decision-making process. I don't think you're going to find any dispute on that. And I think if there was a College Sports Reform Act that could integrate what's happening with antitrust, what's happening with labor, how we handle Title IX, what the tax laws mean, I think we could easily find our way to some mechanism to give the athletes the voice they deserve. Nobody's arguing that.
Matt, can you give us a sense of just how much pressure the NCAA is under? I mean, how litigious is the environment? How fast and frequent are the problems coming?
Well, I think it's important to clarify who's the NCAA. The NCAA, it's a membership association, it's its member schools. No question they are economic competitors for the services of intercollegiate athletes. So any of their agreements, rules that have a commercial effect are subject to antitrust challenge under Section 1. I've been an antitrust lawyer and sports law professor for 40 years, and I would have a very hard time comfortably advising 2 or more conferences and NCAA division to say, you're on solid ground by agreeing to these particular rules. Because it's not hard to say, well, there's a commercial effect on that. One court said that, rules limiting eligibility of junior college athletes, that limits their NIL earning potential. So it's a very serious problem. To pick up on Val's point, to get back to it, one thing I had proposed with one of my colleagues, one way Congress could solve this is create a commission and everyone's voices would be represented, including the athletes, the public, or whatever, and they would voluntarily propose rules. How do you balance all of these things? And then it would be up to the association, a division, multiple conferences, and then whatever was adopted, that would be immune from antitrust challenge. And then if anyone felt that their economic interests were being hurt, it would go to arbitration before independent arbitrators. So I think that's another alternative that could work.
I was going to bring up Major League Baseball, right? I mean, Major League Baseball has an antitrust exemption. I think a broader one than we're talking about here. Is that a fair comparison to say, well, Major League Baseball was granted one, maybe the NCAA has an even better claim than the MLB, or is that not a good standard to judge it by?
It's a good standard to judge it by, but not in the way you're describing it. So yes, in the early 1900s, Major League Baseball was given an exemption from antitrust laws, a broad, all-encompassing one by the Supreme Court. That decision is largely derided by everybody. They came close to losing it. There was a case that was going to go up to the Supreme Court, I think, last year, and it got settled. Surprisingly, the MLB settled it at the last minute before they could lose their exemption. However, that exemption no longer applies to major league players. The Curt Flood Act of 1996, 98, somewhere around there, withdrew that exemption and said that major league players only, not minor league players, are exempted from the exception. But the reason I said it's good to compare it is because you can look and see what happens when an organization has that kind of power. And before Congress withdrew the exception for major league players were under, and up until the 1970s, major league players were subject to what was called the reserve clause. And under that under those contracts, basically once you signed a contract as a major league player, you were bound to that team for your entire life. And even after the contract expired, you couldn't go to another team. They could say that if you say you signed with the Red Sox could say, well, you can go play for the Cubs, but you can't go play for the Rangers. I mean, it was really, really onerous and on the athletes. Also, that exception was granted to them by the Supreme Court before the passage of the NLRB or the NLRA. So it was given before we had these sorts of statutory exceptions that allowed for collective bargaining.
All right, I want to go to the audience after this next question, which I'm going to take one more of. So please get those ready. Again, if you're watching on the live stream, you can tweet those using the hashtag AEI NCAA. I'm curious about the stability of the educations of student athletes in these very competitive environments. We saw the transfer portal. We saw there's recruiting money, especially through NIL, which may not be directly related to this, but the general sort of stability of an athlete's trajectory seems to be much less stable, much more likely to be interrupted with more competition. That doesn't seem good for the educational trajectory of student athletes. Is this a concern I should have, or am I overblowing this?
Let me respond. I don't have the data at my fingertips here, but the fact is that student athletes graduate at higher rates than quote, regular students. And that speaks to the kind of young people that they are. They're highly motivated. They're good time managers. They set goals, and the kinds of attributes that make them successful on the fields of play have also turned out to make them very successful as students. Again, we've got a dichotomy here between two sports where maybe, Matt, the kinds of issues that you've raised, certainly are within the realm of possibility and reality. And frankly, the transfer charts that you showed on the screen, they do make you question whether athletes who are jumping around from school to school, whose credits may not transfer, are they legitimately in pursuit of a degree? Can that really happen? And frankly, that for a long time, that's why the NCAA transfer rules were the way they were. They made you sit a year because the thinking was you're going to need to catch up academically if you switch schools. And now that there were pressures on the system to change that rule, and so now athletes are transferring much more freely. But again, it's really a sport by sport answer. Into the reality of that. And as I said, most student athletes are performing very well in the classroom, and their graduation rates reflect that.
Jim?
Yeah, so first of all, I think that there's a lot of issues with the whole premise that education comes first in a general manner in college athletics, because there's so many examples that show that it doesn't. And I think conference realignment as of late with USC, UCLA, Oregon, Washington going to the Big Ten, and playing sports like women's volleyball or men's basketball where you're traveling across the country back and forth a lot. Matter of fact, Val, credit to you. I don't know if it was true that you guys were looking at Gonzaga, but that would have been tough. And I know you ended up saying, you know what, we're going to focus geographically because we want to put the student first. And so commend you for that, but that's not how the rest of college athletics has been operating. It's, hey, how can we get a bigger media deal for our conference? So let's get USC, UCLA. Cal is in the ACC. Cal is in the Atlantic Coast Conference. And Berkeley's known as a pretty prestigious academic institution. They traveled more than the circumference of the earth this year in college football season. How can that be good for students? And then on the transfer portal, the reason we have a portal, the reason athletes can transfer is because the DOJ said you can't treat non-employees with non-competes. So they said they don't want them to be employees. Well, you can't give them non-competes. But here's the deal. If you talk to those 4,000 athletes in the portal, most of them are not going because they're getting bids in big offers. 10% of them are. The other 90%, their coach is telling them, you will never play a down at this university. And they're like, oh, okay, I guess I'll use the portal, and they go to another school. That's what the transfer portal is. So academics has taken a back seat in certain conferences at certain levels in all sports. Big Ten, that situation I just described with those West Coast teams, that applies to all those sports, and that's a serious thing.
Briefly respond as a university professor?
Very quickly.
Yeah, I'll do it really quick. So I was on a PhD committee of George Kuntz. You might have heard of him. He played in the NFL for a number of years. He did his dissertation on why so many NFL players were broke, substance abuse problems, even suicidal after their career ended. It was because their whole identity was as a football player. And this is what's happening here. People they can transfer, move around, graduation rates are gonna fall. At some point, their eligibility's up. Guess what? Those problems are just gonna be exacerbated.
All right, I want to turn to the audience now. We have 2 rules at AEI when you ask a question. The first is please give us your name, and the second is ask a question. So I'm going to look around here. We have 2 people with microphones. I see a question here. Let's go with Ross Dellinger. Privilege
The reporter,
for his
yes.
service.
My question is mainly for Val. I spoke about earlier the tether between major college football and men's basketball in the higher education institute of the university, and that tether that binds them seems to be stretching. And right now we're seeing athletic directors go to their presidents for more money to fund the rev share. With state dollars, with the school student fees, all that stuff. So at some point, everybody has to lose and win a game, right? Somebody has to lose. So spending millions of dollars from a university into an athletic department that may lose, especially on the lower levels of Division I, may keep losing these games. How long until universities, Val, maybe say, we can't do this anymore?
I think that's very possible that there's going to be dropout, Ross, at some point. We won't know, I think, for at least a year, because as you and others, and we have all noted, this year a transformation is coming to college sports because it's the first year of this new revenue sharing model. As Ross noted in his opening remarks, in his interview, this system is optional. It's de facto required for the autonomy for conferences, but for everybody else, it's optional and they can opt into it. It remains to be seen how this will shake out, what it will mean for schools that don't have the same levels of generated revenue that those conferences have because of their TV media, their TV deals, their ticket sales, their sponsorship, et cetera, their conference distributions. It remains to be seen how that's going to affect subsidies from the university for schools that want to give it a go. It remains to be seen, what it will mean for sports that may be sacrificed so that schools can spend more money on football and high-level basketball because of everything that those sports mean to their universities. It's their front porch, it's donor engagement, it's brand, it's pride. It's pride. And when you hit it, we've seen examples where if you hit it, it's big, if you can hit it. So I don't know where this will land. I do think it's very possible that in the next year or 2 or 3 or more, that we're going to have another reimagination or reconfiguration of Division I as between the schools that can do what the revenue sharing model allows for and those that can't. I think we're just going to see a continuing round of realignment as this evolves.
All right, questions? We have one back here.
Hi, my name is Christian Collins, and I wanted to get quick thoughts from the panel about how there's kind of a lack of discussion around the growing of the revenue pool. Before all the recent changes, and the NCAA and schools have never had a problem growing revenue every year, and with all these new media deals. But then suddenly, as we talk about players receiving compensation and becoming employees, suddenly no one wants to discuss ways to grow the revenue anymore. It just comes like, oh, it's stagnant, and we're just like finding ways to make slices of the pie smaller. And even as we see with like a certain non-revenue sports like women's basketball, where like suddenly all this revenue comes with star players like Caitlin Clark, where the interest has always been there, but there was never the marketing behind it. And I'm just like curious how that all fits into the current conversation around antitrust legislation.
Yeah, so, really what's going on in college athletics is a new $20 million a year expense item, if you're going to fully fund the revenue share, is now having to be balanced in the budgets of all the schools who want to do it. And I would say somewhere around 75 to 80 schools will do it. You'll have $1.5 billion going to athletes through this settlement on an annual basis, and that'll go up as the cap goes up. But all the schools will tell you, even the most wealthy schools that do the best in the revenues, that it's going to be tough coming up with the 20 million because they're used to, as Ross said, as nonprofits, spending everything they make. And that's how you have, a coach making $13 million. Ironically, that coach is also calling his donors, asking them to help him get players. But that's how you have this situation. So now there's two ways to make the budget work. One way is to cut expenses. The other way is to find revenue sources, and the ones that people are thinking about are pretty incremental. It's like putting a logo on a field. It's putting a logo on the jersey. We even heard a commissioner say he might rename the conference with a sponsor name, But the real money is in media money. And if we did what was talked about earlier, where you separated football and it was one league, and you took it for one media deal instead of the conferences all going out separately selling their media deal, there would be billions more a year in revenue. And you could even argue, if you started to look at basketball and women's basketball, to your point about women's basketball's growth, there's growth there. Media money, and you're gonna see the media money grow in this space over the next decade because of what Val talked about with the continued realignment. So I think revenue is going to grow, but it's only gonna be significant through media money. And I think you're still gonna have all the issues that are either solved by an antitrust exemption or collective bargaining when that happens.
I'll just add, that's the issue of revenue growth is very top of mind for athletic departments. And the NCAA, which manages, as I mentioned, upwards of 90 championship events across all three divisions. It has been very heartening to see the growing interest in women's sports, and I agree that there's upside in the commercialization of women's sports, whether they be at the national level, the conference level, or institutionally at the campus level. Because of the interest in revenue growth, you are starting to hear and read more about capital funding ideas. You'll read about whether private equity should come in and offer sort of short-term capital solutions to schools and conferences so that they can meet these growing financial burdens. Whether that's a good idea or a bad idea to take out a loan remains to be seen, and we'll see if any schools or conferences bite on that. But this is a critical area, and I think the pressures on athletic departments will only grow to not only cut costs but to grow revenues as much as they can.
All right, questions from the audience? I've got one right here.
I spent a happy 5 years as the person in charge of the committee that oversaw Montana State University's athletics programs. There are some things I've heard today that are wrong. It depends, that seemed wrong, but Val, you clarified it. The bottom line is that athletes do better on paper because there are sports where athletes are not traveling across the world. Think about athletics, where the GPA is typically in the 3.5 range for the whole team. Historically, some women's teams. In addition, in men's basketball, there's the famous comment from Purdue that we have two people who can't play, but they have great GPAs on our team. So there's a lot of manipulation like that. Here's the real question, though. As you look going forward, the pressures on universities for revenues, period, for their core functions are perceived to be far more at risk than they were even 2 months ago. In that setting, where are the presidents of the universities going to come down in terms of supporting funds that could go to athletics from donors in particular, but also could go to core programs. What does that say about the rationale for either the Wild West, which it does seem to me exists, Jim, in terms of the portal, and you just have to look at the Auburn basketball team to see that, but the overall rationale for college sports in the first place, and college sports under the guidance of the NCAA with interstate commerce rules that universally apply, as opposed to rules that will not be necessarily national laws that drive behavior in individual states for individual universities, say like Auburn or Alabama. I don't know why I think about Alabama, but yes.
So let's get any responses to this?
I don't quite understand the question, to be honest. Wasn't quite sure what exactly your question was.
Given that it's likely that there will be less support among some of these very important universities for funds to drift from donors to athletics as opposed to the core missions of the universities in terms of their foundations. What does that say about your case for the NCAA being able to essentially monitor all sports?
Well, the NCAA doesn't really monitor sports. I mean, they administer the rules that their member schools will come up with. There's a constitution, and then schools group themselves between Division I, II, or III, and there's several divisions within III. I think what you're suggesting is there's probably going to be even more divisions within it, because some schools will say, hey, you know, sports are so important, particular ones, we're going to group ourselves together. But those that do, they have to have the freedom to have uniform rules that are not constantly being cherry-picked and subject to antitrust challenge. That's, you know, pretty much the point that I'm making. You don't, clearly the 1,100 NCAA member schools, not all of them compete against each other in the same sports on the playing field. But those that do, that compete regularly in, you know, and then in the postseason, they've got to have the same rules in order for, that's the hallmark of sports.
Let me ask one question from our online audience, and then we're going to move to the closing statements because we're running out of time. What advantages, this person writes, for athletes does the collegiate pipeline in the United States have over European-style sport academies or developmental leagues like the NBA G League?
You want to take that one?
Yeah, I mean, I think right now college athletes do have an opportunity to develop longer. Instead of going to like a G League is a perfect example. You have a lot of college basketball players that are now starting to stay again for 2, 3 years, even 4 years, whereas before NIL, they would leave right after 1 year, be a second-round draft pick, go to the G League, and you might never hear about them again. The NIL aspect of college athletics, which is donors laundering money through a shell company called a collective and paying players, that is basically keeping athletes longer, and it's in other sports too, but I'll just use the G League analogy.
I'd like to add to that a little bit. I think that one important fact not buried in there, but like shining out of it, is that to some degree, this NIL is keeping athletes in college longer. They are incentivized to stay in school and finish their degree because they're actually earning money. Whereas under the prior system, and to some degree the current system, where athletes are prohibited from any sort of pay for play, you have situations like the tennis players who are currently suing the NCAA because they have to choose between either finishing their education and playing college tennis or collecting the prize money that they earned at the US Open.
Yeah, I just would add, there's no other system in the world like what the NCAA has. I mean, it's just unique in the world. There's no other country where you can have athletics embedded into the education system in the way we've done it here. And the ability to go to a school, earn your degree, get into a school you might not have gotten into, get all the benefits and the life experience benefits that you get from playing on a team, and being able to do what you love, which is play your sport. That just doesn't exist elsewhere. So I think it really is a unique system in the world. And the fact is, because of the attractiveness of that package, the U.S. is training most of the world's Olympians. They come here to college, and whether they're swimmers or runners or playing soccer or whatever, playing basketball, we're doing the world's Olympic training for them because of the uniqueness of our system.
All right, so we're running past time. I'm getting looks from my RA who helps run this. So now we're going to move to closing statements. Audience, this is your chance to make your final decision, and we're going to go in the same order that we started with, and that starts with Val Ackerman.
Yeah, thanks, Nat. I've said a lot. I'll be really brief here. First of all, I just want to thank AEI for the opportunity to bring all of us together. I have great respect for the my other three colleagues here. I hope we've impressed upon the audience the complexity of the issues and the this unprecedented interplay of federal laws. I don't think that, for example, the founders of Title IX envisioned that there'd actually be direct payments made to athletes at some 50 years later. And maybe they would have had strong views on how that should be managed, but it really is unfolding in real time. Our ask, or the ask of colleagues in our space, is for a limited safe harbor to protect the NCAA's ability to enact rules so that it can conduct national competitions. That's really what it does. So it can conduct them predictably and fairly and with the best interests of student athletes in mind. We don't see a way to manage the current uncertainty around all that without federal intervention. And then finally, I just would note, there are analogies drawn with other businesses, but we would submit that college sports are different. They are unique. It's sports embedded in the higher education system, and that they should have some special status because they are co-curricular activities. Not unlike in some ways, forget football and high-level men's basketball, but not unlike school newspaper groups or theater groups or members of the debate team. These are young people who are getting their degrees and they're doing what they love on the side. And so that's the basis for our ask. Thank you.
All right. Katie Van Dyke.
Thank you, Nat. So as I did at the beginning of this, I'll go back to basics at the end. The Sherman Act was not passed to protect business from markets. It was passed to protect the public from market failure. And what we have here, this mess, is the result of a market failure, where the head college football coach at the University of Georgia is paid over $13 million a year, while University of Georgia spends a total of $11 million, or offers a total of $11 million in scholarships for all of its athletes, not just football players. What the NCAA is asking for is an unprecedented request. It upends notions of fundamental fairness and competition that have existed in our country for over 100 years. And it is actually quite broad of an exemption. It would allow the NCAA and its members to unilaterally set compensation for 500,000 college athletes. So with that, I just want to leave all of you with the words of Justice Kavanaugh in his concurrence from NCAA versus Alston. He wrote, "Traditions alone cannot justify the NCAA's decision to build a massive money-raising enterprise on the backs of student athletes who are not fairly compensated. Nowhere else in America can businesses get away with agreeing not to pay their workers a fair market rate on the theory that their product is defined by not paying their workers a fair market rate. And under ordinary principles of antitrust law, it is not evident why college sports should be any different. The NCAA is not above the law." Thank you.
All right, thank you. Matt Minton.
Yes, actually, Congress has recognized that sports are different industries than any others on multiple occasions. Let me just give you two examples. One, it took an act of Congress in order for the American Football League and the National Football League to merge. in the 1960s. In addition, after collective sale of television rights by the NFL was found to be illegal, Congress enacted the Sports Broadcasting Act of 1962, which allowed that. Congress decided that there were overriding public policy considerations that justified anti-competitive conduct by members of a sports league that wouldn't fly in other industries. What we are proposing, and we're not proposing any kind of congressional immunity of price fixing or necessarily preservation of the amateurism model. It's just we're proposing granting of a limited antitrust safe harbor that would be very similar to the implied antitrust immunity under the Federal Amateur Sports Act, which protects the United States Olympic and Paralympic Committee and its NGB's Olympic sport athletes' eligibility requirements and rules from antitrust challenges. So what we're proposing will allow this unique model to be maintained, as Val pointed out. It's, our college sports system is like nowhere else in the world, and it's got some components. A lot of schools like Division III amateur education model. No doubt Division I is a commercial educational model, but college sports are different from pro sports, and they should not be professionalized for a whole variety of reasons, which I'm out of time, so that's it. Thank you very much for your attention.
All right, Matt, and last, Jim.
So when Kavanaugh said the NCAA is not above the law, I was thinking of examples from the past of how they set rules without the athletes involved, price fixed, limited athletes from being able to earn on a lot of different facets. But I actually had a conversation with a Power Conference commissioner recently, and he told me that the House settlement that you heard about from Ross is collective bargaining. Now, if you talk to anybody, and I think Matthew, you'd even agree, it's not collective bargaining, it's a settlement, right? But that is how many leaders in college athletics are feeling okay about this settlement. They're saying, well, the athletes were represented, they're the plaintiffs, and they agreed to these terms. This settlement has already created a ton of issues. Athletes are getting NIL contracts to play at their school, but they think they're going there to play wide receiver. They think that's what the $300,000 is for. The paper on these agreements is telling them they can't do real NIL deals with certain categories of companies and others. And there will be lawsuits over how these contracts are already being done with this settlement. And so the reality is, whether it's that, whether it's the way Title IX is being handled with the settlement, whether it's how the athletes are not involved in how the settlement's gonna work whatsoever, and they're finding out about it through the news, now they follow Ross. The reality is it's only gonna create more problems because the athletes don't have a seat at the table. In pro leagues that have comparable revenues to the revenues we talked about, that's what's allowed. The athletes have a seat at the table. Congress has already acted. That's what is allowed with unionization. So if there's a way to do it as non-employees and still be able to collectively bargain, that's the road to the future, not a blanket antitrust exemption that allows them to continue to set the rules however they want.
All right, so that we'll have to let it rest as far as the debate. Now it is time for our, I'm pressing the wrong button here. There we go. No, we didn't flash those back up. There it is, the final vote is there. It's also at your table. I'm gonna give you about 2 minutes flat to vote, and then we're gonna close the voting. And while we do that, I'm gonna ask for one more question to our debaters. Quickly, rank speculation. Will there be a bill, whether it contains an exemption or not, from Congress this year on the NCAA?
Not one that's passed.
There will be a bill.
There will be a bill, and I think it will be passed.
All right, so we sort of went the spectrum from left to right. We'll have to leave that for another day. Before I announce, and you have about 30 seconds left before Annika, you can shut down the voting. I want to get a round of applause for our great debaters. It was a civil and constructive debate, very helpful. I learned a lot, and I want to thank you, the audience, for sitting through what was a hefty event, and also Ross Dellinger for coming to lay these things out. And they're preparing an envelope right now. Just hold on one more moment. We didn't prime the Jeopardy music, but here comes the decision now. Thank you. Okay, so here are the results from the initial round. The initial round of voting, we had 33% voting for the affirmative, and we had 28% voting for the voting against the motion. The final round, 28% voting for the motion. That's a loss of 5%. And voting against the motion went to 65%, which is a gain of 38%. So arguing against the motion, we have our winners. But again, thank you all for a great debate. And that is a wrap.